Kevin Couch.
Yep, Mr. Couch. One up, three in the middle.
Get their mission faces us all the time, okay?
Judge, Mr. Couch, the plea will be not guilty or waive probable cause at this time.
As to bond.
So Judge, I know you set bonds on the two co-defendants yesterday. We're going to ask you to consider Mr. Couch's bonds separate and distinct from those two co-defendants, as Mr. Couch finds himself in a very different situation to them. Mr. Couch was shot in both the arm and the leg by the same individual who shot the deceased in this case. There's a lot to unfold. I know the detectives here. Obviously, we'll be investigating ourselves about how this all went down. But Mr. Couch is pleading not guilty. He's maintaining his innocence, and he was actually shot by the same individual who shot the deceased in this case. Mr. Couch is here, supported by his mother and father, who are both in the courtroom. He has no history to speak of whatsoever, Judge. He's 19 years of age, no adult history, but also more importantly at this age, no juvenile history. He's a graduate of Loveland High School. He was working for Toyota as a technician up until very recently. And since he was let go by Toyota, he's been relying on his mother and father financially to provide for him, and he lives with them in the house as well. So considering all that, Judge, we know these are very serious allegations. I've talked to Mr. Couch about those, but considering the context of these allegations as they pertain to Mr. Couch, we're going to be asking for a $250,000 and 10% bond, and obviously Mr. Couch will abide by any E&D and juris if the family can even make that. That's a significant amount of money, Judge. We don't think that demeans the serious nature of these allegations. We think that's appropriate for Mr. Couch, considering his lack of history.
From the state.
Thank you, Your Honor. Again, this is a co-defendant for the two other people that were arraigned yesterday. This was a planned robbery where someone ended up losing their life as a result. I do have Detective Pitts here again to address the court. However, I would be asking again for a high bond in this case, secured similar to the bonds that were set yesterday.
Detective.
Your Honor, the defendant here had the rifle as part of the robbery. He also provided the other handgun that was used for one of the co-defendants. So in this case, I echo what I said yesterday, that this was a conspired incident that they planned several hours prior to the incident that ended up resulting in someone losing life and another individual getting shot.
Thank you. On the murder charge, $1 million secure plus EMD lockdown plus no weapons. On the aggravated robbery, $500,000 secured plus EMD lockdown plus no weapons. Terry.
Grand jury report on that will be 8:31.
Thank you.
Great. Last hallway, we'll get that medical. Yeah. Miss Perry.
On behalf of Ms. Terry, we waive probable cause. With respect to bond judge, she has very little if anyone may have prior record, I see a couple of misdemeanors. She does have some failures to comply. I talked with her about that. She understands that she needs to make her court dates, and the quickest way to get a high bond is to not go for court. She's currently pregnant. She has a drug problem. She's engaged with a methadone clinic. My understanding, that's why this is what we call clinics, to allow her to get to that appointment. She has stable housing. She takes care of her mother. I have a good phone number for her. I would ask for an OR bond given the nature of these charges. She was in the hospital, so that's why she was not here yesterday.
From the state.
Your Honor, this is an F5 possession of fentanyl charge. We will defer on bond.
And I believe the two misdemeanors should go along with the felony charge.
Does she have anywhere to go on EMD?
I am not aware that she can, well, I would hope she could, but I don't know. Judge, her friend's house that she'd be living at is in Hamilton, Ohio. I think she could do EMU there, but only if the court specifically allows it.
I'm not going to. It'll be, the bond will be OR EMD lockdown to First Step Home, which has addiction services for pregnant women specifically, or alternative, 2,500 anyway. There are 9 prior failures to appear. First Step Home does transport individuals from the jail. So OR EMD lockdown to First Step Home, or alternative 2,500 at 10% on, that's on the felony. On the misdemeanors, $500 anyway, or EMD lockdown to First Step Home.
Would the court consider an OR on the misdemeanor in the felony bond?
No, there is one if she goes to treatment.
Thank you, Judge.
Grand jury report will be 8/28.
Thank you.
Left hallway, going to take it directly up to medical. Thank you. Everyone done?
Rodriguez.
Louis Caligari here. Louis Caligari.
Good morning.
Maya, you're up. Ms. Rodriguez?
There is a request for a protection order. Hay una petición de que tenga el orden de protección temporal.
Please, myself, you do.
All right, as fine.
Has there been a call for Mr. Louis?
I did not.
Has been. Louis Caligari, please.
Luis Gallagher. Luis Gallagher.
Ms. Rodriguez is executing the protection
Está
order.
firmando la orden de protección la señora Rodríguez.
She is currently represented by Ms. Ali.
La representa la señora Ali Actual en estos dos casos.
From my understanding, she has expressed,
Ha expresado
Ms. Rodriguez has been the victim of
la señora Rodríguez
abuse by Mr. Calgary.
ha sido víctima de abusos por parte del señor Luis.
She has shown a number of scars on her body from
Ella ha demostrado numerosas cicatrices en su cuerpo de incidentes que tuvo con él.
She is connected with our social work division.
Está en conexión con los servicios sociales de nuestro despacho.
Her social worker came over this morning to check on her
La trabajadora social vino esta mañana para ver cómo estaba
and expressed that she had had concerns about her safety yesterday when she lost communication with her.
y tuvo problemas ayer y se preocupó porque perdió la comunicación con ella por su seguridad.
But that we are prepared to make sure she's connected with women helping women
Estamos preparados para que ella se pueda conectar con mujeres ayudando a mujeres
so that she has a safe location to return to.
para que ella pueda tener un lugar seguro donde volver cuando salga de aquí.
Um, Without entering the admissions to the facts on the record,
Sin admitir los hechos que constan en la denuncia.
I do believe that this may be an instance of an abusive relationship that
Creo que
is
esto es un incidente de una relación completamente abusiva,
abusive in ways more than physical or emotional,
también
but as well as financial and providing
motivos
the
económicos
stability
y
that she
físicos,
needs,
sino también motivos financieros. También ahí está el curso.
which is why we're working actively to make sure that she has alternative structures.
Por eso estamos intentando que ella tenga alternativas financieras para poder sobrevivir.
She does have a job, she works in a warehouse.
Trabaja en un almacén,
She's given me an alternate address she can stay at, which is 40 minutes away.
una dirección alternativa que está a 40 minutos de donde reside la supuesta víctima,
We're asking that you consider releasing on OR or SOR.
y le pediría que la liberase bajo palabra o bajo palabra con supervisión.
From the state,
Por parte de la Fiscalía,
The allegations here are that
las alegaciones son
the defendant bit the victim on the back of the leg, causing visible
que
injury.
la víctima
Also, she was seen by police
la acusada
officers
mordió a la
at the
víctima
same
en la
residence,
pierna,
grabbing
causando
onto the victim.
lesiones.
And the court has already ordered, she's already got a TPO in that effect.
Ella tenía una orden de protección temporal que se le había sido impuesta por otro juez en otro momento.
If the court is concerned about her contact with prosecuting witnesses,
Si esta juez está preocupada por el contacto con la supuesta víctima,
we ask that you consider OR with juris.
le pediría que considerase bajo palabra con monitor juris.
I am going to do OR plus EMD with a 3-mile radius from the prosecuting witness's
Palabra
home
con monitor electrónico de 3 millas
so
fuera de
that
donde vive la
they
víctima
can stay away from
para
each
asegurar
other regardless if the defendant, I'm sorry, the prosecuting witness wants jurors. There's already one
del radio de acción
pending.
para asegurarnos, aunque rechace el juris, de que se mantiene alejada de él.
So until these are resolved,
Hasta que se resuelva este caso,
the defendant
la acusada
is not to go within 3
no
miles
puede acercarse a 3 millas
of that Glenmore
de
address.
3 millas de la dirección de Glenmore.
Does she need an escort to get any personal items? Do you need that checked?
Necesita que se le acompañe a recoger sus objetos personales.
Yes, we ask the
Sí,
prosecuting.
por favor, marque la
It
casilla
can be
número 3.
checked. And would you explain to her that she has to have an escort and
Ella
then
tiene que ir escoltada
she
por
gets
la
one
policía
chance
a recoger
to get
sus
everything
cosas.
that is needed?
Solo va a tener una oportunidad
until the
de recoger
case
sus
is resolved.
personales
We did
hasta que
discuss
sus
that.
asuntos
Thank you.
se resuelvan.
More. Oh, I'm sorry, and you said she's gonna be living
Ha dicho
40 minutes away, so I'm assuming it's out of county.
Que va a vivir 40 minutos.
Can I have that
fuera.
back so I can put it?
Por favor, tráigame el expediente otra vez.
No, the judge sheet.
She's there.
I don't, you need a back.
Both of these. I just need to put that on here that she can live out of county if she's gonna be living out of county.
Fuera del condado, okay?
I'll let you all figure it out. I'm gonna put it on there anyway.
Thank
and
you.
then you can figure it out.
You need a second.
More,
He's right here. This is driving table, right? This is work driving table. Work driving table. Right there. This is driving table, be it now.
I think this got this.
this is a M1,
No, I believe it's a minor. A minor.
this one. Oh, they have it listed as an M1 on the sheet. Okay. Do you need to, is there anything OR on the traffic? I'm gonna go with Sebastian because I cannot.
Left hallway can come off the register. Left.
Sebastian R.
Sebastian.
Claro, no, culpable al señor Díaz.
This is a second in time.
Una vez en el plazo legal
Is it a second overall?
y la segunda vez.
I believe so, Judge.
Sí, creo que sí, señor.
And accident,
¿Hubo accidente?
No accident.
No, no hubo accidente.
FRA,
Personnel.
Nuestro seguro, no, nuestro seguro.
test,
There was a breath test of 0.208.
2208 fue el test de la alcoholemia.
ALS,
Suspensión administrativa en su expediente.
They did not check the box on the ALS.
No marcaron
Under suspension.
la casilla para que se le suspenda la capacidad de manejar.
So based on that high test, I would ask for a public safety.
Así que le pediría, dado el test de alcoholemia alto, que le suspendiese esa capacidad de manejar por razones de seguridad pública.
That's fine, Your Honor. Mr. Rakiak is 36 years old. He does have two children, age 13 and 7 years old that live with him.
Que viven con él,
He works as a mechanic.
trabaja como mecánico.
He is the sole supporter
Él
for
es
his
el
family.
único que ingresa y mantiene a su familia.
Judge, we understand this is the second in time. We're just asking for a
Pero le pediría
SOR. He has zero failures to appear, and besides the previous DUI, no record other than that.
manejar tomado, no tiene ningún otro antecedente.
from the state,
Por parte de la fiscalía,
Your Honor, again, I would be asking for a public safety
le
suspension.
pediría que suspendiese la capacidad de manejo por razones de seguridad pública,
Based on this being a second in time,
basado que la segunda vez en el plazo legal y en total,
with a prior in 2024,
el antecedente es del 2024
and a .208 breath test,
y que dio como test .208,
I would be asking for no alcohol and TAP as a condition
le
of bond.
pediría que como condiciones de la fianza le prohibiese la ingesta de alcohol y le pusiese monitor de detección.
OR plus TAD,
En
Plus,
palabra, con
no
monitor
alcohol,
de detección de alcohol en el tobillo y no puede consumir alcohol
the A and B,
mientras está
a
en el
public
plazo.
safety suspension is
Se le prohíbe
imposed
la capacidad de manejar
OR on the driving without a
bajo
license,
palabra por su licencia
unsafe vehicle, and signals.
y por no poner las señales del vehículo y por no llevar el vehículo seguro, también bajo palabra. No beba nada y ahora le van a decir.
West,
You get the back.
thank you.
Left, right. She's done each OR plus that. West. We know.
Good morning, Judge. Warren Thomas on behalf of Mr. West, please not guilty.
Esteban.
Esteban, Mr. West was here yesterday and arraigned on some older cases. I think these came through later, so he's currently being held on a bond. We asked for a low nominal bond on these. Speaking with him, he's currently represented Mr. Nazarene, and I'll be reaching out with him. He's set for a pre-trial next week on Tuesday. I do believe he's in a position to post some amount of bond, so we would ask the court to consider a low bond in these cases. Looking at his criminal history outside of those cases from 2019 that he's currently facing, I see very minimal record beyond anything in 2009. Additionally, he does, he's a full-time caregiver for his mother. That is his primary concern and goal in being able to return home, as well as his grandmother. He does not reside with the prosecuting witness in aggravated menacing. He is quite confident that will not survive a trial setting. This is a situation where he is kind of the provider for the family, in that disputes come out, those individuals are not appreciative of him trying to take care of the home and take care of the family, and then charges him about instance to get him to go from the home so that they can see the family back. With that, Judge, we would be asking the court to consider the low bond, given the presence of a holder, and his ability to post some bond given his family.
From the state.
Your Honor, on the theft, I would be asking for a stay away from Home Depot. On the aggravated menacing, it does involve an allegation of brandishing a firearm and stating he would shoot the victim. So I would be asking for a stay away from the prosecuting witness in that case, as well as a no firearms order as a condition of bond.
Both of these allegations are from 2025. The bonds on each will be $1,000 anyway, or alternative OREMD on the ag menacing, stay away from home, on the ag menacing, stay away from the PW. On the theft, stay away from Home Depot. No firearms on the ag menacing. Wood.
Permission to approach. Thank you.
Thank you. Is there a complaint that has the actual allegation on it?
I have a complaint on Route 819-226 in Hamilton County, State of Ohio. Defendant did knowingly cause serious physical harm to Kenneth Stanton Brown by means of a deadly weapon or dangerous ordinance. And then it says, 2 at 1 shell casing.
It says what?
2 at 1 shell casing.
As the weapon,
That's the weapon.
and then there are no allegations on the complaint or the affidavit.
Not that I have, Your Honor. I have the police report that says the defendant shot the prosecuting witness with a firearm. The defendant suffered from a single gunshot wound to the back under his arm.
I guess that's what you see.
All right. As to bond,
Judge, over my left shoulder is my client's uncle. Last night turned this young man into the Elmwood Police Department. Not only did they appear and cooperate, they also brought along the gun that may or may not have been involved in this issue. There are no charges here for weapon under disability or improper handling or anything like that, because he is licensed to have and hold and be in possession of the weapon in question. I've known James since the day he was born. His mother and has been a civil client in our office for over 40 years. He will stay with his uncle. He will stay on house arrest. And you and I have been here 100 times and not more on these types of situations. The people involved all know each other. The people involved were, to say the least, very pugnacious at the time of the incident. My client is putting the state of Ohio on notice that this would be a self-defense, if nothing else, or self-defense of others' case. Period. The state of Ohio has a high burden here, a high job here. They're going to have to corral people involved to get them to a grand jury, because law unfortunately clearly doesn't know what happened here. My client's been cooperative. I can't speak to the victim's history because I don't know it, but I will speak to my client's criminal history. It's a zero across the board. His family has put together a $20,000 at 10% global bond that they can make. Other than that, he'll sit. And what we all know that grand jury days come and go in this county, these types of situations, and suddenly there's no go. I've had three in the last month myself. So I'm asking the court to consider my client's lack of record, his and his family's cooperation, and promises that he'll be here when told to be here if necessary. Thank you.
From the state.
Your Honor, the state would be asking for a high secured bond in this case. The victim stated that there was an altercation going on between the defendant and another individual. The victim went to break up this altercation and ended up being shot in the arm area. It was right under his arm, near his shoulder. He did suffer from gunshot wounds, had to go to the hospital as a result. These are very serious allegations. I believe a high bond is appropriate in this case, as well as I would ask for no firearms as a condition of bond.
As was stated, Mr. Wood has no record, no failures to appear. The allegations are serious. The bond reflects that, but also the fact that Mr. Wood has no record, $250,000 anyway, plus juris, plus no firearms.
Grand jury report will be 8:31.
Addis.
Thank you, Your Honor.
Thank
you. $25,000. Substitute.
What was the grand jury on that one?
8:31.
These were added from yesterday.
Yes, Your Honor.
Oh, he was back there. Judge, I will ask the court to allow me to waive Mr. Addis's presence and still address it.
Waive probable cause.
Judge, I actually would like to hear probable cause in this case.
Your Honor, on or about August 18th, 2026, in Hamilton County, state of Ohio, the defendant did knowingly use a .22 Ruger handgun and is a drug-dependent individual being diagnosed with substance-induced mood disorder. This was related to the case yesterday where the defendant officer went to his house due to a shot spotter activation for 5 shots that were fired. When they arrived, the defendant had a knife, brandished the knife. It took them a while to get that out of his hand and to get him into custody. Eventually, he did admit to having the firearm and hiding it in a trash can in his laundry room. This was at an apartment complex where multiple individuals were present. Based on the complaint for the inducing panic charge, it caused an evacuation of that apartment complex. He made threats of harming the police or they would kill him, causing an approximately 2-hour standoff between him and the police in the apartment building and in the parking lot.
As to the allegations themselves, the allegations meet A4 of the statute. So probable cause is demonstrated from on the face of the complaint. As to bond,
Judge Esteban, on the weapons under disability, the state is essentially charging Mr. Addis based on an alleged drug dependency. The Supreme Court actually just ruled on this instance in June of 2026, which involved prosecuting a habitual marijuana user for having a weapon. The Supreme Court actually deemed that that is a violation of the Second Amendment. In this case, there is nothing in Mr. Addis's history about drugs. He has no drug convictions. He has no pending drug charges. There is nothing in the complaint that mentions that drugs were even found when he was arrested. His sole convictions are for misdemeanor BPO and misdemeanor disorderly conduct. His ORAS score is a 2, and that's simply based on his age, and one is based on one failure to appear. So again, there's nothing in Mr. Addis's history that notes anything about drug use. And it will be interesting to see if this case actually survives grand jury, because the state will have to prove some sort of drug dependency. Based on that, Judge, we obviously were in front of you yesterday for the same incident. The state must have thought about it, decided to add charges, so here we are again. He's been in the state's custody since Monday. Yesterday, the court imposed a $20,000 bond. Mr. Addis still hasn't posted that, so I would ask the court to consider OR and D on these new charges that the state just added.
from the state.
Your Honor, again, these are charges that were added by the officer, I guess yesterday after the defendant was arraigned on the same conduct. Based on mental health concerns and a firearm being involved, I would ask for a monetary bond in this case.
Is there any reference anywhere to what substance he was either alleged to be under or that there's an alleged dependency to?
No, Your Honor, I read the report this morning and they do not mention any specific. at the report, it does say that he mentioned he needed to stop using hard drugs.
What does it say?
When they arrested him on the police report.
5,000 anyway on the having weapons under, 1,000 anyway on the inducing panic. Price,
Manager report will be 31. Thank you. It'll be on the same day. It'll be 28. Thank you. It'll be 28 on that.
This is off the 10:30 docket. I'll move the waive Mr. Price's appearance, just not guilty.
all right, is there anything from the state? OR.
Thank you.
Murray,
Murray is also off the 10:30. The reason this had to be called on the docket is because the grand jury added a charge. And I don't have it in front of me which one doesn't have a bond, I think.
the theft was added.
And so Judge, Murray is still being held, hasn't been able to post the current bond.
Anything from the state?
Sorry, Robin.
Thank
OR.
you.
City domestic violence docket. Chitwood,
Request for 2 protection orders. Kevin Johnson here and Nathan Johnson here.
Please not guilty, Judge.
all right.
For the record, I was informed that Mr. Chible's case is in conflict with our office. I won't be designated on this case to do all of that.
All right.
As to bond, Mr. Chitwood, it seems that these cases are from early July. The date is July 10th. It's my understanding that one of the prosecuting witnesses, Ms. Gammon Johnson, is Mr. Chitwood's fiance. It's my understanding that she was unaware that charges had been filed, that they have continued to be living together since this incident, that they are still in a relationship. Despite that, he is willing to sign a protection order. He has given me an alternate address as well as contact information for his father. After the incident, the prosecuting witness, Mr. Johnson, did move out of that home, so he is no longer living in the home with them. As I said, he is willing to stay at his father's house while the case is pending. I don't believe that there are any failures to appear. Mr. Chitwood works in flipping homes. That's an off and on job. He does construction. It doesn't provide a consistent source of income. So right now, he does not have any money for cash bond. We would be asking if he is willing to sign protection orders, and that he has an alternate address that he's with OR with the document that we're doing.
From the state,
Judge, the allegations are that Mr. Chitwood, as to Gavin Johnson, grabbed her hair and pushed her to the ground. As to Mr. Nathan Johnson, the allegations are that he punched Mr. Johnson in the face after a verbal altercation. I note that he has some dismissed domestic violence charges, perhaps one felony on his record.
he's executed the TPO.
Yes, we'd ask for Ms. Gammon Johnson's testimony that expect me to check if you do live together at that residence, if he's able to go back to police escort to retrieve his belongings.
I can't hear counsel. You're asking what?
Box 13. Yes, he can get his personal items with the police escort. There are 4 felonies. I have one violent misdemeanor, but I do not see what the actual charge is on that. 3 misdemeanors, 0 failures to appear. He's executed the TPO, and of note, both prosecuting witnesses refused to sign or fill out the safety questionnaire. OR plus juris if requested. Day.
Can we go hang a left the whole way instead of about 10 minutes when that meeting goes? Walk plus sure. Right middle next to your turning, you'll be up there in a second.
Good morning, Judge. Please not guilty.
Bond.
As to bond, it seems that the protection order that was in place at the time of this violation, has now been dissolved. The underlying charges were dismissed on August 11th. The allegation of contact here states that there was a vehicle accident where Mr. Day was alleged to have come in voluntary contact with an individual he has a protection order against. Without getting too much into the facts, Mr. Day has expressed to me that he was driving and his vehicle ran out of gas near a viaduct. He had left the scene to get gas can. I believe that because the vehicle was at that viaduct, that there may have been an accident behind him. He comes back, sees the prosecuting witness, and leaves. And I think that that is reflected based on the parking, the improper parking traffic ticket that he has. He left his vehicle at the scene. He did leave when he saw that the prosecuting witness was there. In addition to that, those underlying charges with that prosecuting witness have been dismissed. That was continued. At least it was continued from July 16th at state's continuance. It was ultimately dismissed on May 11th. The protection order is now dissolved, and there doesn't seem to be any movement by the prosecuting witness to do a civil protection order or make any additional means to try and keep contact away from Mr. Day. So for those reasons, we'll be asking that you consider an OR bond. I know that there may be 2 failures to appear. However, he was present when these cases were dismissed. So at least on this most recent charge, he has not failed to appear.
Judge, the complaint says that the officer's witness is subject on the scene speaking to the protected person.
There's no record, 2 failures to appear. The protection order at issue is not in effect right now. The OR bond. Mr. Day, these cases are assigned to me. If you don't show up, you will not get another one. Are we clear? Stay in contact with your attorney. Haynes.
Yo, man, hang a left with no burner. OR. Mr. Haynes. President, next to your attorney.
Please not guilty.
As to bond.
As to bond, Mr. Haynes is currently working as a staffing manager at People Ready. He's been there for 6 years. He's supposed to work today. He was able to coordinate with one of his coworkers to make sure that he was able to use PTO today, but he does not have an unlimited supply of that judge. He does have a security guard he's been out for 6 years. He has 4 children that he financially provides for. He does have joint custody for those children. It's my understanding that these charges were from the end of June. The individual that is listed as a prosecuting witness, he has had no contact with since this incident. That it was Mr. Haynes who called 911 that night. that he was unaware that he had a warrant until he was in a traffic accident where they had ran his license and informed him that there was a warrant for his arrest. He has had no contact with them, and I don't believe that he and the prosecuting witness have ever lived together. He was the only individual on the lease. This was a short relationship, which has ultimately been ended since then. He is willing to sign a protection order. We're asking for no more bond for signing a protection order.
Judge, there is a request for protection order. Is Lori Alexander here?
He's executed the TPO.
The complaint states that he grabbed Miss Alexander, leaving visible red marks and scratches on her arm.
OR plus juris if requested with the TPO. Felony lockup docket. Crandall. There's a solicitor.
Randall, or Curtis.
Sarah.
So they just took her upstairs. She was the one that was screaming. I was just informed.
Crandall was?
Yes.
Judge, I have Mr. Suarez's designation. He's met with her, so the court's okay with proceeding here.
Waive probable cause.
Yes, Your Honor.
As defined.
You're setting bond on a 5th-degree felony, and she is appropriate for treatment for drug court. It's my understanding she has significant medical issues. She has heart failure, and she has a liver condition as well. She has a stable address. I think there's a friend here today to support her. We'd ask the court to consider supervised OR bond.
From the state.
We'll defer on bond, Your Honor. So these are December 24.
There are 6 failures to appear on the A, B, and C. The standard bonds will stay in place, which are 500 anyway. The current KPS bond of 5,000 will be modified to 500 anyway. And then the felony, 1,000 anyway.
Can you consider an alternate immunity?
Yes, it doesn't look like she's had EMD before. Alternate ORMD.
Grand jury report will be 8:31.
Daniel.
And 26.
Daniels.
I'm putting Mr. Suarez's designation for Arnold Daniels as well. This is also appropriate for drug court. Waive probable cause.
All right, is there anything from the state? There are 0 failures to appear. There is 1 violent felony from a very long time ago, and no other record, no failures to appear.
Nothing from the state.
I'm sorry,
Nothing from the state.
and you waive probable cause,
Yes, Judge.
OR, or supervised OR.
Thank you.
Grand jury will be 9-3.
Duffy,
Good left hallway, go home.
Right down the hallway, no bad.
Right. Can we come out? The attorney is right nowhere now. You got full attention, he does.
Judge, I'd like to hear probable cause specifically as to the weapons under disability.
And on or about August 19th, 2026, in Hamilton County, state of Ohio. The defendant had at hand a Taurus G2C 9mm handgun. He is prohibited from possessing firearms due to a prior felony drug trafficking charge out of Hamilton County in 2019 and a robbery charge out of conviction out of Kenton County in 2017.
So may I address that?
Yeah.
So the complaint says that it's based out of a charge out of Kentucky. And then if I look at the pretrial report, it's really difficult to see what happened with those. It says robbery dismissed,
they're
amended, it's just really hard for me to tell.
their convictions, and if you go down, I see what what it says, but if you continue reading the weapons under disability complaint, it says the complainant states that this complaint is based on defendant fled from a vehicle with listed firearm. Defendant is prohibited from possessing firearms due to previous felony convictions. So it is inconsistent within the complaint, but it does have in the convictions, and there are, it looks like these might be federal.
It's really hard for me to tell.
But I do have conviction
Okay.
on my sheet at least. So probable cause is found, Esteban.
As to bond, Mr. Duffy lives here in Cincinnati. I know that he has those previous charges from Kentucky, however, he's lived here in Ohio for his whole life, except for those couple years that he lived in Kentucky. He does have a good address here. I have good contact information for his mother and his brother. He is working for Moore's Janitorial part-time. I'd ask the court to consider it more bond for him today. 0 failures to appear in the last 5 years.
From the state.
Your Honor, I think a high monetary bond is appropriate in this case. The defendant has firearms, he is not allowed to have firearms due to that robbery. And drug trafficking charge convictions, based on my reading of the pre-trial report, it looks like he also has been charged with possession of a firearm prior convicted felon. If I'm reading that correctly, it looks like he's been convicted of that in 2019 in Kentucky. So he knows he's not allowed to have guns, he still continues to have guns. I think a high bond is appropriate in this case.
I have 1 violent felony, 2 felonies. Mr. Duffy was convicted of a prior with the federal charge, drug trafficking, a weapon, possession of a firearm by a convicted felon, same as weapons under disability basically, which he got 36 months for. On the weapons under $5,000 secured. On the CCW, $5,000 anyway. On the F5 possession, what is the drug?
It is methamphetamine.
Is one pill correct?
1 pill.
OR. And on the obstruction, OR. Pause.
Grand jury report on that will be 8:31.
There is a common stakeholder and a late on request.
Pause.
I'm submitting Louis Suarez's designation for Mr. Pauls. This is another drug court case.
Does he have somewhere to go on EMD?
Okay, yes, Judge, he does, he has his own permit.
All right, is there anything from the state?
No, Your Honor.
OR, EMD, the EMD is because there's 5 prior failures to appear.
Grand jury on that would be 831.
All right, recalling Haynes. Where are we?
Just let me know if you need them. I have
There's another case that's not from this judge that you have to take care of, okay? So you're done.
Judge, I asked you to recall Mr. Haynes' case. I understand that
You
the
bet.
bond was
You bet.
larger
You
as
bet.
requested. Just to reiterate, Mr. Haynes has a job, he's been out for 6 years. He does need to be back at work tomorrow. We were going to be asking if he would be willing to consider an alternate cash bond of $5,000 at 10%. That is something that he and his family can post. That would get him out of here faster so that he's able to maintain that job and stay providing for himself and his children.
Anything from the state?
No.
Alternative, 2,500 anyway on each count. Heel.
On behalf of Ms. Hill, we would like to cause.
You, Ms. Hill? Yeah. You gonna go right out? You're turning up there? That's the first one.
Your Honor.
You said waive probable cause.
Cause.
Is there anything from the state? Ms. Hill has no record, no failure to appear, F4 receiving stolen property, and a temporary instruction permit.
Nothing from the state.
Unless it's OR, unless you want to argue something.
I can stop talking if I'm waiting.
OR. Holly.
Grand jury report on that will be 9-3.
Mr. Holly's waived, it's not gonna drop down. Judge, my understanding is he was waived yesterday, rather than continuing on with that, I went up and saw him, asked to waive him today. I will be designated on this case. I would ask to hear probable cause on this.
On or about August 19th, 2026, in Hamilton County, state of Ohio, the defendant knowingly caused or attempted to cause physical harm to the victim in this case by means of a metal CD tower, he struck him in the face with the CD tower, causing injury to his lip and face. The only indication of injury that I have in the report, it looks like a bloody lip.
Judge, it's felonious assault, it has to have serious physical harm. There's absolutely nothing that I can see in the narrative or the complaint that indicates it's anything more than physical harm, which would be a misdemeanor assault.
Is there anything from the state?
Your Honor, my only explanation in this would be that they charged the metal CD tower as a deadly weapon. However, the injuries are, from what I can tell, just a bloody lip. So.
So the court will find probable cause demonstrated because, well, serious, non-serious, or what deadly weapon is relative, and I will let the grand jury work that out. For purposes of setting bond, we're going with the bloody lip. So you can make the argument as to that. A bond argument, that's what I'm looking at this point.
As to bond judge, I believe that Mr. Holly, if I'm doing that correctly, is 66 years old. He lives here in Cincinnati. I would argue that the allegation here is on a bloody lip on a felonious assault is weak. I would ask the court to set a bond commensurate with that level of physical harm.
From the state,
In this case, I would be asking for a stay away from the prosecuting witness. We'll defer on her behalf.
2,500 anyway, or alternative ORENB. Kincaid with the stay away.
Right here, part of that will be 831.
Ms. Kincaid? Oh, I know. Kim Redmond,
Hopefully, guys.
All right, Esteban.
Your Honor, Esteban, while I see that one of these is charged as a F3, I do think that there is a potential that these end up getting changed and put into drug court. I know one of them is a trafficking, reading the report, just trafficking. I think that will either go away or be significantly lower. So I expect that that's probably what's going to happen here. She lives here in Cincinnati with her parents. I have a good address for her. She does door dashing. She does it so much that she considers it work. She does it all the time. She's done it for a year and a half. She has no violence on her record. It looks like it's just crimes similar to this. I'd ask the courts to take that into consideration. I'd ask for an OR.
From the state.
Your Honor, the defendant in this case was found unconscious in her vehicle in a Kroger parking lot. When they searched the vehicle, they found fentanyl in a syringe, methamphetamine in, I think it was 3.5 grams, and then also 2.5 grams of fentanyl in addition to what was found in the syringe. They charged trafficking for, I believe, the amount of methamphetamine that was found. We'll defer on bond.
I think they tried to allege that the meth was in a gum wrapper and that was prepared for distribution, which, again, I'll just stay. I don't know.
There's 4 felonies, 4 misdemeanors, 4 prior failures to appear. These look like they will most likely go to drug court as was stated. 1,000 anyway on each count for alternative OR in the
Grand jury will be 831.
Also, if the defendant makes the bond, she'll be on pretrial random.
Is that for EMU or just for posted bond?
That's for the post and bond. Period. All right, Lattimore.
Can we left hallway, go sit down 10 minutes, way down to the hotel, okay? Not more.
Thank you.
Level doing? No, they put probation hold on. Put probation hold on.
Which I'm gonna waive probable cause on this. My understanding is they put a probation holder on him, so I would ask the court for a nominal bond. He's gonna have no bond on that until he's in front of Judge Walker.
Is this a having weapons under or a CCW? I have CCW on my bond sheet and having weapons under printed on the judge's sheet.
It's charged as having weapons under, however, I can't believe it should be a carry.
I think the complaint is carrying a concealed weapon,
Oh,
and
it
then the pre-trial report says carrying a concealed weapon. I think it got put in by the clerk's office into the wrong code section, but the complaint is, I believe, accurate.
Carrying concealed weapon.
Okay. Alright, so are you asking for a nominal bond? Is there anything from the state?
Asking for a no firearms order as a condition of bond.
1,000 anyway. I'm not putting a no firearms order on because it looks like he can legally own a firearm, just from the allegations not conceal it. And there's no allegation of him using it improperly. Murphy,
Your injury report on that will be 831.
Sure, I can take a picture. There's Mr. Murphy. Come out, you go right in the middle, and bring to me back.
Your Honor, as to bond, so this is a situation where the prosecuting witness is 16. It is a nephew to Mr. Murphy's partner. Mr. Murphy has his name on the lease. It is his house that girlfriend lives at, or partner lives at, and she and Mr. Murphy agreed to let nephew live there. Nephew, I think, also has been in and out of Lighthouse. He is also on probation. It seems like nephew has some issues, and Mr. Murphy made statements to the police that day indicating that they had an argument, that the nephew was being disrespectful to his aunt, Mr. Murphy, and was not being a very good house guest, not following by the rules, and they had an argument about it. I think it is important to note his age, that he's 16, and that he, at least my experience with some teenagers, tend to act out and say things that maybe aren't true to get their way. Mr. Murphy is adamant he never choked him. He said that they did have an altercation where they were yelling at each other, but nothing ever happened where there was a strangulation involved. He is currently on disability and will be on long-term disability from the Ford factory. He has epilepsy and in April had an implant put in his brain to help with his epilepsy, which made him not allowed to work at the Ford plant anymore. So he's on permanent disability. He has not had, I don't believe, any contacts recently with the court. He has one violent felony, and I don't even know.
I can't find it.
I can't find it either. Him and I talked about it. If it's on there, it's really old. He's got nothing from Hamilton County. This is his first, at least it looks like from my record of him.
2008 is the last thing that I have,
Is
as
that-
far as conviction.
Yes, but not from this county, I don't
Right.
believe. Yes. Yeah, so he has just been working up until recently. Now he's on disability. He's just being a law-abiding citizen. I think this is maybe a troubled teen that Mr. Murphy and his partner were trying to help with, and just didn't end up well, Your Honor. He has no issues staying away from the nephew of his partner. That's not going to be an issue. I guess the only concern is, I think that the nephew is now moved. I don't know if they took him back to Lighthouse or where he is. But it's my understanding that nephew will no longer be at that address since it is Mr. Murphy's apartment or house.
From the state,
Your Honor, in this case, the victim, who is 16 years old, did say that the defendant strangled him, causing him not to breathe for about 10 seconds. He did have visible marks on his neck. Based on those allegations, I would ask for a monetary bond in this case, as well as a stay away from the prosecuting witness.
So as we said, there's one violent felony, one misdemeanor, no failures to appear. The last thing that I have is from 2008. Bond, supervised, OR plus stay away from PW.
Grand jury report will be 9-3.
9-3.
Niehaus,
Go, hey, go ahead, let this one run. Mr. Niehaus. In the right middle next to your attorney, she says, "I would." Thank you.
We'll waive probable cause.
Esteban.
Your Honor, Esteban, so this incident occurred in Cincinnati allegedly, but Mr. Niehaus and the prosecuting witness do not live in Ohio, they live in Indiana. Mr. Niehaus indicates that he can, however, stay here while this case is pending. Because he works here in Cincinnati, he has lots of friends here, he gave me the name of his friend that he can stay with here, that's here in downtown, so it won't be an issue with him getting to court. He's adamant he never misses court, and he takes that as a priority. This is with, I guess supposedly it happened while they were working or maybe on lunch break. He is adamantly denying his allegations. He was shocked when officers showed up to his workplace. He works for Lane Painting. It's a unionized company. He is in the union. He is on the payroll. He's been painting for pretty much his whole career, but he's recently with Lane Painting for about a month and a half. He was picked up yesterday from the officers at work. He's expected to be at work today, so he's very paranoid about missing work. He also has rheumatoid arthritis that has been causing him some issues in here. And I know he is on medication. I'm not sure that the Justice Center has provided him that or will provide him, if they can even provide him his medication for that. But it is a concern that he has. I would ask the court to consider giving him an OR, alternatively an OR EMU. As I stated, he can stay here in Cincinnati. He has no issue staying away from her while this case is pending. I believe she'll probably just stay in Indiana and not be here in Cincinnati. So as long as he's here in Cincinnati, I don't think they're going to have contact. So again, I would ask the court to consider an OR. He has 0 failures to appear for the last 5 years. I think that this case will resolve itself, potentially a grand jury, and if not, we'll set it for trial.
From the state.
Your Honor, in this case, the victim and the defendant were at a job site painting. When they returned from lunch, the victim told police that the defendant choked her in the car, almost causing her to pass out. They then arrived back at the job site and he choked her again, lifting her off the ground, causing her again to almost pass out. The defendant has a prior domestic violence conviction out of Indiana from 2024. Based on those allegations, I believe a monetary bond is appropriate. I would also ask that the TPO be executed in this case.
Here at TPO.
He did
Oh, okay.
serious.
Yes.
There's one violent felony, one violent misdemeanor, 0 prior failures to appear in Hamilton County. It looks like all of Mr. Niehaus's prior offenses are Kentucky or Indiana. As was stated, there was a prior strangulation and domestic battery, of which the strangulation was dismissed, and there was a conviction for the domestic battery, as well as an intimidation conviction. 10,000 anyway on each count, plus juris if requested.
Grand jury report on that will be 8:31.
Strickland,
Sid Strickland, Your Honor.
yes.
Sure, again. Strickland, young man, come on out, right middle, your attorney's gonna be over there in a second.
Is there an Andrea Walker?
Ms. Walker, can you come up to the box right here, please? Do you have your ID?
Fully present house.
Good morning, ma'am. Would you like to say anything in regard to the case?
Yes,
What would you like to say?
I'm aware it's under the judge's discretion for this charge. I would like to state that I don't have any fear of Jonathan Strickland, nor does my family for me. He has never ever raised his voice at me prior to this incident. I don't believe the incident would have occurred had he not drank almost a fifth of alcohol. He's since attended therapy and is sworn to never drink again. I want to again say I have no fear of any harm towards me or anyone else. He's never been anything like he was in that incident. I don't believe that the incident that occurred would ever happen had he not drank. And I would like to do anything to help alleviate the charges or drop them.
Do you want a stay away order?
No.
Do you have any position as to bond? So the charges will not be dismissed today. Once they're filed, it becomes the state's case. But do you have a bond position?
Can you state what that means?
A position on how much a bond would be set out for him to be released, or any specific conditions for his release?
I would like him to be able to continue therapy because I believe that it's very helpful for what's been going on. He has not drank, and I don't believe that drinking would be helpful for him. So if he cannot drink outside of that, no bail. I don't have no position on that. I don't believe he needs it.
All right, thank you, ma'am. Is there anything from the state?
Your Honor, I would be asking for a no alcohol order.
Mr. Strickland has no record of violence. There are 3 misdemeanors, 0 failures to appear. Based on that and what the prosecuting witness has said, the bond will be OR plus TAD plus no alcohol. Mr. Strickland, you will have an alcohol monitor on that will monitor if you consume any alcohol. If you consume alcohol, your bond will be violated and you can be picked up. Understand? All right, thank you.
Thank you, Your Honor.
Tribble.
Grand jury report on that will be 9-3.
What's your name, ma'am?
My name is Princess Nelson. I'm Jermel Trouble's mother.
Okay, thank you.
I'm just gonna give this person.
Yep.
I'm submitting Louis Suarez's
That's all right.
designation. This is
You know, Warner. Right in the middle. Next turn, we get their big got 4 sets of these.
to waive probable cause. Your Honor, I'm aware that there's a holder from Warren County. It's my understanding that's a misdemeanor. So I think it's a neighboring county and it's gonna be relatively easy to take care of. He's asking the court to consider a supervised OR bond, but he could probably afford a low monetary bond. He just can't do EMD. He has a high school diploma, a college degree. He's a father to 5 children. he obviously has family support.
Is there anything from the state? It looks like there are 2 oxycodone pills.
Nothing from the state.
Supervised OR.
Thank you.
Grand jury on that will be 9.
Quarters in recess.
Left hallway, I was doing a little war rock, we will hold Warren County. Evening time out.
Yeah. I have started.
We've been checking on morning.
Yeah, I've seen all the other ones. The newest one, I'm like through 6 holes. Yeah. Those guys, they correct me up. Yeah. Well, the other 2 were not like bids. He was the 4th string. He was screwing the thing all day. Yeah, that was why he filled yeah, pretty much. He flat out said, you know, like, I was just 4th string. I was just there, you know, whatever. The man was high up, but with the main guy, he was big.
Is he the dark hair guy?
No, Witt's the light hair guy. Yeah, Biz.
How he swings. He swings like.
Yeah, he looks like his chopper. Yeah, and he was the one that said all day, I maybe so. He got really popular on Twitter, just chirping at people, messing with them and stuff. That's why they get along so well.
He's the one that I thought was.
Yeah, he is. But yeah, and he was. That was his job too. Yeah. That he'll like if you watch the newest one, he talks. Yeah, he talks.
Yeah, because that's why.
Because he's riding with Bob. Yeah. You know your job.
Yeah, so that's all you want me to do is take him out.
Yeah.
Get on that ice cream. All right, buddy.
Breathing heavy today. Looks like no, hold on. I'm sorry. Yeah, that age. Yeah. You're like 14.
You need the date on this? What she knows, why she
That's okay. See my locker?
Brenda's face.
Let's see, walk-in is. Bring forward.
Court is back in session.
Mr. Foley's here.
Raymond Foley.
He said he does.
Oh, Capias, 1,000 on each count at 10:27 a.m. Arraignment,
Arraignment.
Lucio Arraignment.
I have a request for production. My mom.
All right. Is she gonna execute the TPO?
Yes, Judge, she's willing to sign the check. Please not guilty, and as to bond, Ms. Arraignment is a registered nurse at Mercy Health. She has no criminal history, no failures to appear. The allegation was that a coffee mug was thrown at prosecuting witness. She has a 13-year-old child. Her mother and father are here in support today. Her and the prosecuting witness do not live together. And she is willing to stay away from him. She has signed the protection order. We're asking that she's released on OR with the signing of the protection order.
Is there anything from the state?
Just asking for the TPO to be executed.
There's no record, no failures to appear. OR with the TPO.
Thank you.
Beatty.
He's arrested on an
Come back. Really good attorneys and we'll talk for you, okay?
Is what? All right. Mr. Beatty, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to a minor misdemeanor disorderly conduct?
Yes, ma'am.
Counsel, do you wait and stipulate?
I do.
Finding of guilty.
In mitigation, he is employed, however, the majority of his money goes to his two children.
From the state.
Nothing from the state.
One, credit one, remit the fines and costs. Roll now.
Going home.
Have a good rest of your day.
Yes, let's go turn back in, about an hour or so, we will get you out of here, okay? Run out. Take one day. Just ready. Yep, Ms. Burnow. Call on this down. Yes. Hi, good morning. Hello, good morning. Good morning.
Please not guilty on her behalf.
What number is this?
It charged the third in time, Your Honor. However, looking at her record, the two priors that they listed on the ticket, 2019 and 2025, were reduced to reckless operations. So it should be a first OVR.
So the B charge would not be valid.
Not in this one.
I'll put an OR on the B. All right, as to the A and the C,
Yes, Judge, as to bond, I do represent Ms. Brona for a pending charge currently that is driving under OVI suspension. As the court is now aware, there are no previous OVIs. We think that Ms. Brona has a habit of having officers incorrectly charge her, looking at her record and kind of the previous case I'm representing her as well as what's going on here. Obviously, I don't know much about the current allegations in the OVI. I will throw Ms. Brona under the bus. I've looked at her record, I've spoken with her about this. I do think she has a bad record of being a bad driver, which invites these charges, invites these allegations. I don't know the previous history of why those were reduced and what that was. I do know a second time being reduced for a wreck is generally quite rare. She does have 2 children at home that are starting some form of schooling, a 3-year-old beginning in preschool and daycare, and a 7th grader. She does have a 19-year-old who does assist in some capacity, but she is the primary caregiver for all 3 of these people. I've been in great contact with her over the course of my previous representation. We've spoken at least 5 to 10 times discussing this previous charge that's set for trial in September. And as the court to consider an OR, no driving with cab if the court is concerned about alcohol consumption. I've spoken with her about no driving. Her 19-year-old is able to drive, will do the driving in the meantime until we're able to secure privileges if able, as well as the condition of no alcohol will not be an issue.
from the state.
Your Honor, based on the record, I would be asking for TAD as a condition of bond, as well as no driving. Did they already get called? What's the last name?
Alright. Ms. Brownell has 11 prior driving under some type of suspension convictions. So in no driving order from me, I have zero confidence in. There are, in addition to the convictions, 4 pending with 3 different dates that are pending as of right now. On the OVI, I will set that bond like I set any other first, with what the allegations here are, OR plus CAD plus no alcohol. On the points suspension, $2,500 anyway. Connolly,
The court consider an alternate.
with restricted hours. It will not be an open hours EMD. Alternate OR EMD with curfew. And I'm gonna put it on here. No driving. And if defendant picks up, I'm putting on the judge's sheet, picks up another charge for driving, that the bond should be revoked on this case.
Judge, for that alternate, is there tab on it?
No, that one, the tab is on the OBI. Connolly.
Where is a common place order?
10 minutes, bro. Who's not good morning? Conley? There you are, young lady. Ready? We're gonna write the middle of you now, real quick.
The plea is not guilty.
Good morning, Ms. Connolly. Long time no see. All right.
She is interested in considering,
Change court? I will, well, these are my bonds out of change court, so I'm not gonna change them. I'll put it on the docket for Wednesday for change court. That's Wednesday state. Yes. 26. Continue. 124 at 1:30. For change court. All right, I'll see you Wednesday.
Farmer, right?
Farmer,
I'm gonna right for you. Great to meet you up in a second. When we get there, get a full attention face forward. Now we're gonna set it up, huh? Now here, make you face down. Take care of it. Cletus, the Sewell.
are you, okay, can you come up to the box? Do you have your ID? Do you have anything with your picture and name?
Good, ma'am, I was just a quarter across the street.
All right, what do you want to say?
I would like to say that I don't want to press charges, no CPO, and that I'm going to be coming to the board.
Okay. Well, so once the case is filed, it becomes the state's case. That's number one. The state, if it feels serious enough to pursue it, can get personal service and compel you to come in handcuffs to court. But outside of that, as we are right now with the two cases that are pending, are you concerned for your safety or the safety of any children?
No.
Based on what you said, I'm assuming you do not want a TPO.
Correct.
And is there somewhere that Mr. Farmer can stay separate?
He does have an alternate address.
Is there anything from the state?
Your Honor, I would be asking for a stay away in this case.
How far does the father live from the joint household?
11 miles.
OR plus EMD with a 3-mile radius from the PW. It looks like this is not the first issue between the parties, so until it is resolved, the court is ordering that the two of you have no contact. He can go get anything he may need with an escort.
Am I able to take that to his father?
Yeah, I don't have any control over what you do, but what he does, his bond can be revoked. Court is putting that in place because of the parties' prior incidences and the allegations that there is a video of the alleged incident.
He has a sister in Mount Healthy. We can put that address for his sister's house.
He can give them anybody address as long as it's 3 miles from hers. Houston.
Left all the way to the farmer, and then yellow for the four listening to you. Houston, Houston district. Come out, right in the middle, can't see your attorney, do you have to wait on them?
The plea is done. And as the bond, he is
Is there anything from the state?
Yeah.
There's no record, no failures to appear, OR, unless you want to say something else. All right. Killings,
Boogeyman, right this way, and hang a left up in the hallway, yellow footprint, be with you in a minute. That's everything I say. Killing. Yes, sir.
Destiny Hamilton,
Right middle, full attention.
I spoke with Destiny. She's not able to be here, but I do have a photo of her ID and a text from her using the number that I got off of the statement, stating that she does not want a temporary protection order. I'd like to see that. They do live at separate addresses.
They do live at separate addresses?
Yes.
All right. And the party share. Thank you. Did you show the state? Is there anything from the state?
Your Honor, the victim in this case did have physical injuries that officers observed due to the defendant striking her in the forehead with a closed fist. She had a large bruise on her forehead and several other scrapes and bruises on the rest of her body. Because the victim is not here, I would ask that the protective order be executed, and if she wants to come to the first setting in court and ask for that to be dissolved, we can do it that way. If not, I would ask that there be a stay away in this case.
And you said the parties do not live together. All right.
She told me that she did not want drugs, she does not want CPO, and that she informed officers at the time that she didn't want
I am going to order a stay away, no contact. For the PW. So for the child, somebody else will need to do any exchanges. The bond is going to be OREMD. The EMD is because there are 6 prior failures to appear. It'll be open hours, but it will be EMD because of the number of failures to appear. McAllister.
Ready? Remember I told you this morning? Remember I told you this morning? You're going home. Yeah. Go walk see you. McAllister.
Are you Mr. Harper?
Go on. Not ready to move. Next to your turn until we get there. Make sure you hold.
So this started as a pillow fight? Alright. Once the charges are filed, it becomes a state's case. Do you have a bond position? Are you concerned for your safety or the safety of any children? No. Is there anything from the state? Ms. McAllister has no record, adult or juvenile, no failures to appear. OR. McLean.
Right. You left OR to come up front of the hallway, okay? You are getting married, so are you. The plane is a cloud. Right in the middle next to your turning and way on the hallway.
Not guilty for Mr. McLean.
Alright. Esteban.
Esteban, Your Honor, Mr. McLean is 62 years old. He tells me that he does receive disability. That's about $1,600 a month. This is a situation where I believe the prosecuted witness is his wife, ex-wife, wife. He tells me that he was not sure about the protection order. There is some confusion as to, I'm gonna look more into this, but as to when he was served. He tells me that he does have somewhere else to stay. He can stay with his parents. He does have 0 failures to appear. No, not He doesn't have much of a record, Your Honor. We would just be asking for a SOR, if the court is inclined, to give, Mr. McLean a, monetary bond, that it be a low monetary bond.
From the state.
Your Honor, in this case, the defendant texted and called the victim multiple times after being served the protection order. He did admit to doing so. Based on the protected parties' statements and the defendant's brother's statements, they believe that the defendant has an alcohol problem. So I would ask that no alcohol be a condition of bond.
And I will note, he did turn himself in.
OR plus TAD plus no alcohol. There's no record of violence. There's 2 misdemeanors, no failures to appear. McCullum,
Left, oh wait, over was that. Yep. This is my brother. You want right in the middle, your turn.
Not guilty for Mr. McCollum.
most, let's see.
Esteban, Your Honor, Mr. McCollum is 30 years old. He has 2 children that he takes care of, ages 3, and then 11-year-old boy. He is the full-time caretaker of his father, who is actually in hospice right now. He gets, his employment is also through VA. He gets paid to take care of his father that's in hospice. He tells me he's really concerned about that because he hasn't been there. He is the only caretaker for him. I know he does have failures to appear. However, he doesn't have much of a record. He has one misdemeanor and 5 minor misdemeanors. He has adult convictions. Your Honor, I do have good contact information for him. Most of this is shopping stuff. He tells me that he is in the process of getting his license back. He has been making payments to Progressive and then to another party. He has about $1,000 left to pay off that, and then the block from his license will be removed and he will be able to get that. We're just asking for a SOR bond.
From the state.
Judge's capers for these 6 cases.
So there are 13 failures to appear. This case has already been assigned to a trial judge, and the trial judge set the bonds. I'm not going to change her bonds. On all of the traffic, she set OR bonds. And then there was 500, actually that was a magistrate bond. So I will change that to OR on the magistrate bond, but the judge's bond on the M1 will remain the same, which was $10,000 anyway.
Okay, would the court consider an alternative or EMD?
No, I'm not gonna change her bond.
Okay, thank you.
Ross,
I have a request for protection.
I believe.
That's what she had, she just knocking. Ross.
This is not guilty for Ms.
Ross.
Ross.
what's your name, sir? He's speaking.
Right,
Stephen Ross.
All right, do you have your ID?
Ms. Ross, does she have full face to test, please? The attorney, lovely attorney, will take care of the rest.
All right, what would you like to say, sir?
Yeah, again, I was called under control, but I don't want to pursue any charges. I'm not in any fear of being able to check the court.
Are you concerned for your safety or the safety of any children?
We don't have any children, and I'm not concerned.
And do you have any bond position or any bond conditions that you're requesting?
No, Your Honor.
All right, thank you. Is there anything from the state? She has no record, no failures to appear.
No, you're-
OR.
Thank you.
Stevenson,
I'm left, holding OR.
Is waived. I'd asked to waive his appearance. I do believe this is the third day he's been waived. He does have a current folder, so I'd rather just sign on and get this case moving along if possible, asking for a nominal bond.
is there anything from the state?
The stuff from Kroger, Your Honor, $106.
I will put Judge Mallory's bonds back in place on the 11458. His bond was 1,000 anyway. And then the new bond, there hasn't been one set on the 26 case ending in 16223. That bond will be 500 anyway.
I just asked her to stay away from GFS on that one.
Plus stay away from GFS. Taylor,
Jimmy, busy?
Renfield, next time, Mr. Chairman. Please not guilty.
does Mr. Taylor have somewhere to go on EMD?
So
Judge, he could do EMU, however, I would be asking the court for a large, given some circumstances, I'd like to inform the court of regarding this temporary protection order.
I'm listening.
So Judge, I understand that there's an alleged temporary protection order. I do have a copy of a motion to modify or terminate that temporary protection order that was filed back June 29th by the prosecution. As I have heard, there's a copy.
Can you show it to the prosecutor first?
I also have a copy of the scheduling order in response to this.
can I just address you? I'm not
Hold
gonna say
on,
anything.
hold on for 1 second.
Don't worry.
Yes, ma'am.
Many a person has found themselves in jail by not letting their attorney talk for them.
Yes, ma'am.
Just trust me, don't
I'm gonna shut up.
Is there anything from the state?
Your Honor, this was a case where the defendant was found in the same vehicle as the protected party. We'll defer on that.
So, Mr. Taylor, I'm going to say something and I don't want you to say anything at all,
Yes,
okay?
ma'am. Yes, ma'am.
Until the court terminates it,
Yes, ma'am.
it's in place.
Okay.
You're the one with the protection order.
Yes, ma'am.
You're gonna go to jail every time until it is terminated.
Yes, ma'am.
You got about 2 weeks, if that, maybe even a week.
Yes, ma'am.
Stay out of jail. OR.
Can I hug you? Can I give you a hug?
Absolutely not, but you can go on, you can have a great day.
Oh, please. That's awesome.
Quiet it, have a good day, sir.
Left. Yellow for right in the middle, that's your journey to the
Please not guilty.
All right, is there anything from the state? No record, no failures to appear. It looks, is this age related? No.
I think it was just failing to disclose when all.
Okay. OR. Williams. He'll be out about an hour.
Is that your?
Yes.
Got it. Left hallway, with every my corner filter after the Right, no, it's your attorney. Full testimony.
Please, not guilty on behalf of Mr. Williams.
All right. What number is this? This the first ever
Based on what I have, Judge, I believe,
accident,
no accident.
FRA,
Marked no,
test,
refusal.
Hey, Ms. Williams.
ALS,
It is not in place based on, it's like they didn't check the box. They did report an odor of alcohol. He admitted drinking, red glossy eyes, slurred speech, and short-term memory issues. I would ask for a public safety suspension in this.
there's no record, there's one thing pending, 0 failures to appear. The court is going to impose a public safety suspension. Other than that, it'll be a OR bond.
Is that on all charges?
Yes.
Judge, on the city case, could he stay away from the victim's residence, 2670 Latham Road?
Hold on for 1 second, stay away from,
Queen Israel at 2670 Latham Road, number 301.
are you Miss Gray? All right, just come over to this door right here, ma'am. What is this? Failure to confine the dog.
Yeah, Corbin, love that guy. Left or right? Corbin. He's
Good
OR.
morning, Miss Gray. Did you pay the bond?
I don't even know nothing about this, because the officer that came to my house, she gave me a ticket, and she said it was the right one, and I guess the following day, she gave me another ticket saying it was the actual right one with a court date, and I didn't know that court date until like.
I'm gonna set an OR bond on this, all right? You'll go to room 117 to get your next court date, all right? So just go out that door right there. Thank you. Thank you.